So, here we'll discuss the last portion relating to the principle of natural justice, and that is failure to give reasons. So, where the reasons for the decisions are not given to the person concerned, or reasons are not given to the court, the order is quashed and the authority is directed by the court to examine the matter afresh as it was decided by our apex court, the Supreme Court, in the very important leading case, Travancore Rayons versus Union of India. So, where the reasons are not communicated to the person concerned, that they are on record, and also in some cases the court has upheld the action, but in some other cases the court has not upheld it, as regarding Ajanta Industries versus Central Board of Direct Taxes in 1976. Supreme Court has held that recording of reasons on the file is not sufficient. It is necessary to give reasons to the person concerned. In this case, the order was quashed on the ground that the reasons were not communicated to the person concerned. The view expressed in Ajanta Industries versus Central Board of Direct Taxes appears to be the better view, as reasons are for the benefit of the party concerned, and therefore they should be communicated to the person concerned, and they should not be confined to the record or file. So, this view, as tendered by the apex court in regarding Ajanta Industries versus Central Board of Direct Taxes, is one of the better views of the court regarding the very failure to give reasons, as the very court or the authority has quashed the very order of the plaintiff. So, in that case, the very reasons under which the very decision or the order is arrived, it must be intimate to the very person or the plaintiff, as it is the very necessary ingredient of the principle of natural justice. Only if the very reasons of dismissing the very grievances of the plaintiff will be only in record, then it would not be any help to the person who is aggrieved or the plaintiff. So, this is all about the failure to give reasons as per the decisions of the Travancore Rayons versus Union of India. The decision was delivered by the apex court in 1971, and in the Ajanta Industries versus Central Board of Direct Taxes in 1976 by the Supreme Court. And of these two views expressed by their lordship, the Supreme Court, the latter view that was expressed in Ajanta Industries versus Central Board of Direct Taxes, is found to be a better view regarding the failure to give reasons. So, in our videos previously uploaded, already we have discussed the very principle of natural justice, and we have exclusively dealt the principle of adi alterum partem and the second principle nemo judex quas sua. So also the very regions or the region decisions, that decisions which are based on regions, and also the very exceptions were to natural justice, and such exceptions that we have already discussed, exceptions of application of natural justice by statutory provisions, by constitutional provisions, by legislative act, and in application of the principle of natural justice in public interest or in circumstances such as in emergency or on the ground of impracticability or in cases of confidentiality, so also in cases of academic adjudication and where there is no infringement of any legal or constitutional right, and in cases of any preventive action, and that preventive action is interim in nature, where the very principle of natural justice is not attracted, so also lastly in case of fraud, and in that case we have discussed the most important leading case, and that is UP Junior Doctors Action Committee versus Dr. B. Sitla Nandwani, and in 1991, and that was regarding fake producing of certificates regarding taking admission into postgraduate medical course, and by producing fake certificates or fake orders of the court was held as a ground of fraud, and in such case the very cancellation of the admission of those candidates who produce fake orders of the court and by that taking admission was held not violative of the principle of natural justice. So, regarding the very principle of natural justice, we have already dealt in our previous videos which were uploaded in this channel. So, anyone or any viewer, if wants to find the detailed principles of natural justice, both regarding odi alterum partem or nemo judes quaso, they can refer to our previously uploaded videos to find out the correct and the exact answers relating to the very principle of natural justice.